Welcome to the Orlando Sentinel's editorial board interview with candidates for the 5th Judicial Circuit, Group 13. This circuit includes Lake, Sumter, Marion, Citrus, and Hernando counties. In this race, we have Zach McCormick, who is a Taveri civil litigation attorney, who has also served as the chair of the 5th Circuit Judicial Nominating Commission. He's challenging veteran circuit judge Heidi Davis, who has been on the bench since 2010, handling a wide variety of cases, including civil, criminal, and family. And I'm going to go ahead and start with the first question. The phrase judicial temperament is often used to describe those qualities a good judge should exhibit. In your opinion, each of you, which of those qualities do you believe is most important, and how would you strive to exhibit judicial temperament, the proper judicial temperament, as a circuit judge? And we'll start with Mr. McCormick.
Well, first of all, thank you all for having me here. It's an honor to be able to speak on such important topics. I happen to have asked this very question a good number of times because in my capacity as chair of the Judicial Nominating Commission, it's almost precisely the question that we have to ask because we're in the business of helping to pick judges. The first thing, of course, that I realized when I first took over that position now, not quite, but almost 6 years ago, was that I needed to tap into the collective knowledge of those who have come before me. And so by polling the bench, that is to say, judges themselves, as well as the private bar and the public bar and the lay public, the answer to your question, how important is judicial temperament, is that it's extremely important. It is one facet, however, of what goes into making a good judge. The others include the need to be able to move cases. And that's a term of art, but at its core, it simply means that in addition to maintaining your courtroom in a respectful and efficient manner, you must also bring cases from their inception all the way through to conclusion in a timely manner. Because, of course, justice delayed is justice denied. And so in my capacity, the answer to the question, well, what makes a good judge, including the questions, as we've already discussed, of judicial temperament, ends with, you've got to be able to do all of it well, efficiently, and respectfully.
Thank you. Judge Davis, same question. What qualities make for a good judicial temperament?
I think there are a number of qualities, and just like every judge is a different person, every judge has a different way of approaching or handling it. For me personally, I think one of the most important qualities is to be a good listener, to listen to the litigants, to listen to the lawyers, their arguments, and make everybody feel like they have had a full and fair opportunity to be heard in your courtroom. I think that is key to a judicial temperament that is successful. Also, I don't think that the courtroom is a place to terrorize anyone. I had once had someone tell me that it's great to take your job very seriously, but not yourself so seriously. And I kind of live by that motto. Other than being patient and being respectful, I think that listening and just, not being an ogre on the bench is what makes for good judicial temperament.
Thank you for that. I will jump in with the next question. I know that a really recent decision in the last little while by the Florida Supreme Court could weaken some restrictions on what judges can say about their political or partisan or ideological affiliation. What's your view of that decision, and will it change the way that you campaign? And I'll start with Judge Davis.
Well, honestly, given the rules that are out there, I'm not sure how much more restricted we could possibly be. Um, there was another recent opinion that indicated it was okay for a judge to indicate that they were conservative. And I'm familiar with that. The other is just kind of falling in line with everything that has already been set out there. Obviously, we are nonpartisan. Um, at the bench, we are nonpartisan while we're running or campaigning. And as you probably are aware, there are some very strict rules that we have to adhere to during our campaign. And certainly separating politics is one of those.
Thank you for that. And to be clear, it is that recent ruling about being able to state that you're conservative is sort of what I'm referring to. But you answered the entire question. So, Mr. McCormick, what are your thoughts?
I believe a careful reading of that ruling would yield the interpretation that it is permissible for a judicial candidate to express that they take a judicially conservative approach. And there is a distinction that must be made there. I know of no authority which has changed Florida's canons which govern judicial races and judicial candidates, including judges themselves, that would permit any sort of open affiliation with any partisan act or action. So I would track Judge Davis's conclusions that there may not be quite as much change as perhaps some have thought there might be. The term judicial conservative would reflect more of an originalist's perspective on how the law should be applied and whether or not there is discretion on the bench to create a law or an interpretation of a law that did not previously exist.
Thank you both for those answers. I wanted to kind of switch the field from the external appearance of things that you might see or do to the internal. Judges, especially in circuit court, are required to rule on issues that are almost always very high stakes. Lawsuits involving millions of dollars, felonies that could demand the death penalty, and cases that will set the future for a family or a big corporation. There is so much, and we all come to our jobs with personal feelings, religious traditions. How do you reconcile those personal beliefs that you've had all your life with the need to follow the law and rule consistently? And I would like to start with Mr. McCormick.
Thank you. Part of the training as a lawyer, which is of course the foundation upon which every judge position is built, involves the principle and the training to compartmentalize one's own personal interests and viewpoints. It is essential to the job that one focus on the job. To try to answer the question as directly as one can, I've served in the public sector. My first job out of law school was as an assistant public defender. You don't have higher stakes than that. I currently have my own civil litigation firm, which I have had for the better part of the last decade. So when you're looking at the monetary side, you have equally, or I should say similarly, high stakes for some. You're not involving questions of liberty. Obviously, on a criminal side, you're looking at the possibility of someone losing their life. That is the ultimate penalty that you can see in the state. On the civil side, you can see essentially bankruptcy as a consequence of losing a civil case. I've handled those types of cases. I've had to sit next to the client who had to live with the consequences. And that's been instrumental in forming not only my career, but the experience that I now intend to bring to the bench. One cannot allow any concern for the outcomes of justice to impede the administration of justice. And that means you have to make tough rulings. That means you have to put people away, and that means you have to issue verdicts against a defendant or a plaintiff, depending on the circumstance. But the critical element is that you must have the resolve to do what is necessary to protect the community and the fabric of the law and order that underpins it.
Thank you. Judge Davis, same question.
And so as I understand it, the question was, how do you sort of separate those personal feelings, beliefs, ideals that you hold from bleeding into your rulings or as a judge? Is that summarized it? It is a very difficult job. It sounds like it would be pretty easy. The law is there. You read the law, you apply the law. It's all said and done. But every case has its own unique issues that go with it. People are people and everyone is different. And sometimes the law doesn't always fit the circumstances. And that is just true. It is heartbreaking when you have to impose a law that you do not believe personally fits the circumstances, but it happens. And that's what we are charged to do, is follow the law and apply it. There are times when the judge has some discretion in how something turns out. And I think, it's completely proper for a judge to use compassion and look at the totality of the circumstances in those few cases. I'm mostly speaking from the criminal bench, where there is some discretion on how you rule. There is certainly a lot more discretion in the realm of family law, because that is so fact intensive and very emotional as well. But from the criminal perspective, yes, it's primarily follow the law, and where you can use your discretion and you believe it is appropriate, I think it's important to be compassionate. And that's my answer.
Thank you. I had a quick follow-up if I could. It's sort of related, but wanted to talk to you both about recusals. I know that recusals obviously happen where there's personal conflicts, and I wanted to know what your policy is on recusals in general, and if there's ever a position where you would recuse yourself because of an ideological conflict. Judge Davis, we'll start with you.
Not as an ideological conflict. I have shied away from animal cruelty cases just because I think they're heartbreaking. But there has not been something, say, political that has come before me, or something that I have been afraid to tackle. I don't think that is the reason for recusal. It's not a personal, is there an appearance of impropriety toward the litigants? And I think in my career, 14 years, I've probably only recused 3 or 4 times. And that was because I was personally familiar with one of the litigants or something. If I ever have any doubts, then the best thing I think is to always disclose, oh, I met this person, at a function, or our kids played soccer together 5 years ago. Does anybody have a problem with that? Those are the reasons why I believe you need to recuse, is if there is that appearance of impropriety. I don't think a judge should ever shy away from something that is perhaps politically difficult for them, ideologically difficult for them. That's what we're here to do, is apply the law to the facts. And so to the extent that recusals are used for that, I can't say personally that I have done that, but that's my opinion on that. Thank you.
Great, thank you. And Mr. McCormick, I know in your case we're speaking hypothetically, but I would love to hear your thoughts on the matter also.
So, of course, my perspective as an advocate is something that means I've actually had to deal with these types of questions on behalf of various clients in the past. And what was said earlier about adhering to the rules. We, as either judicial candidates or judges, are governed by those canons. The Florida Supreme Court has been insightful in helping us to navigate these types of challenges effectively. The answer that I would tender involves a recitation of the reality that every judge has an obligation to maintain the public's trust by avoiding even the appearance or semblance of impropriety. Any judge that puts the public in doubt as to whether or not a citizen is being treated equally under the law will not be doing a service to their community. Now, I'm speaking in general terms here. With regard to the political question, judges have to look at every case as they come. So one would not be able to speak and paint with a broad brush, because in fact, there could be instances where, if the circumstances were correct, hypothetically, you could see the need to recuse oneself because of a political ideology. Fortunately, as a separate but co-equal branch of government, the judiciary is largely insulated from questions of at least partisan politics. And so for the most part, these types of scenarios never come to pass. But it is important to always remember it is about preserving the public's trust. So we can't answer the question generically. We do have to look at each and every individual case and make a ruling based on that.
I was working in Lake County when they launched one of the state's first teen courts. And since then, Lake has added a veterans court. Other counties in this circuit have drug courts, DUI courts, other kinds of specialty courts. Which specialty or problem-solving courts do you think would be good options for Lake County, and which should they consider or initiate? And we will start with Judge Davis.
Well, obviously a drug court, and I would preface that with it, a drug court, mental health court. The two go hand in hand. Many times it's mental health issues that are being self-medicated with drugs. Sometimes it's drugs that are bringing on psychosis. These are issues that are hand in hand. So a mental health drug court program is long overdue here in Lake County. I can give you a little sneak that we are in the process of getting something together for that. It has been in the works for some time. We just want to make sure that we follow the best practices, that we have something that is evidence-based for the money that goes into that, to show that this is actually working for the community. We are partnering with the county and have great support for that, but wanted to make sure that we were doing everything by the best practices we can find out there. I think it is a much needed court here in Lake County. I think it's a court needed everywhere, from the opium crisis to now fentanyl being everywhere on the streets. It is something that needs to be addressed. I don't know if the courts are always the best solution for social problems, but this is one that kind of ties in with the criminal justice system. And I think it is an area where we can see some great progress once we get that going.
Thank you so much. Mr. McCormick, what specialty courts would you like to see introduced in Lake County?
Well, first of all, I'm a huge proponent of the teen court program. It's an interesting full circle story for me for a number of reasons. And I'm curious if you knew Carol Custer when she was administering the teen court program. Everyone has done a wonderful job, but I'll tell you, I started in teen court, if you can believe it. And I mean, I've been in this county, as a child. I'll tell you this, and I tell everybody who ever asks me about it, should my child attend? I say, absolutely, absolutely, because I still to this day use the basic courtroom procedures taught in teen court. So I can say nothing but good things about it. And after having got into the private practice, I actually am very proud of the fact that while I was the local bar president, I actually sponsored a Teen Court Excellence Award. We gave out scholarships to some of those top performers in that teen court program. And in fact, at least one of them has now gone on. She recently graduated law school, and we're just absolutely thrilled to see it. It's a wonderful, wonderful program. Can't say enough good stuff about it. And perhaps in many respects, it is an example of the success that you can have when you have the right motivation and the right funding, and you're doing things really to benefit that community. With regard to what other courts there are, there are a lot of different issues that come before this legal system. So arguably you have, one court, and then the discretion vested within each individual judge as to what would be appropriate. Now, we do have sentencing guidelines, and I have to reiterate, they must be followed. That is part of what the judge's job is, even when it's difficult. But with regard to what we could see to help to improve the community within the framework that we have, to add to what was already said, we also have a veterans court in several of the counties in the circuit. And when you're looking at the needs of veterans, it's impossible to overlook the variety of unique concerns that they may have. So if I had to pick one, in addition to the teen court, I would add the veterans court.
Thank you for that. I also wanted to in a general way, speak to resources. And I know this is not something that you necessarily would have control over from your perspective, but I wanted to ask about access for those who speak languages other than English, and also those who are either visually or hearing impaired, and whether you think that there are enough resources in courts now to handle such cases or such situations. And in a perfect world, what would you do to add to that? Or are there specific things that you would do to help alleviate those? And Mr. McCormick, we'll start with you.
So as an assistant public defender, we had quite a few folks who had needs that ran the gamut, whether it touches on the language issues that you mentioned, or whether it related to any other limitation on access. I think you touched on probably the prime issue, which is always resources, right? Every single given area is going to have a limit to what they can afford. I'm proud of our circuit. I'm proud of our county. I got to know many of our interpreters quite well. I thought they were very dedicated. They were hardworking. They still are. I'm sure they would agree that they could always use more backup. And I'm certainly an advocate for that. But there's a more nuanced issue that's implicated by the question of access. And it deals with, do we even need to get into the actual courtroom? And I say need because every citizen is entitled under the Equal Protection Clause to due process of law and equal protection thereunder. As a civil litigator, I'm also certified as a mediator by the Florida Supreme Court, and I'm a huge advocate for alternative dispute resolution. I'm also arbitrator eligible under the Supreme Court guidelines. And it's occurred to me, and frankly, people far wiser than myself, that one of the ways that we could both facilitate access and do it without taxing the resources that are already in many cases stretched thin is to implement a mandatory pre-filing alternative dispute resolution diversion for at least civil actions. There are some types of cases where this would not apply, for instance, in the criminal areas or in some of the family law areas. But at least as far as the civil backlog is concerned, requiring people to go to mediation before they file their lawsuit is something that we've seen successfully implemented in things like homeowners association disputes. And so it can greatly reduce the caseload and thereby allow those who have matters which can only be resolved in court to have access, greater access to those necessary and precious resources.
Thank you for that. Judge Davis, what are your thoughts?
I'm going to ask, would you mind repeating the question? Because if you wouldn't mind.
Not at all. I was mostly asking about resources, specifically when it came to people who come to court speaking languages other than English, also for those who are either hearing impaired or visually impaired and therefore have issues being fully invested in the court process. I wanted to know sort of how would you, in a perfect world, reallocate those resources, and what are areas right now that you think are shortcomings?
I think when it comes to an actual court proceeding in the courtroom with the judge and both attorneys and everybody there, we're pretty good about having that service available, whether it be the language line. Primarily, we have Spanish interpreters. Obviously, that's the biggest call. But we also get Creole. I had a Marshallese one time. So you have to have that availability, and we do in the courtroom. I think Mr. McCormick brings up a good point that not everything happens in the courtroom. And there are a lot of times that people are confused about what to even file, especially if they are doing this pro se, may not have a lot of money. And I think that in those cases, there's probably not enough resources out there for self-help, legal aid. I'd like to see more available so that people understand what they're getting into before they walk into the courtroom. We have some excellent interpreters, and with the use of technology, we can make better use of their time so they're not driving back and forth from somewhere. They are central in one office. It does sort of diminish having somebody there in the courtroom, and technology doesn't always work as it should, so sometimes there are issues. But overall, I think we do a very good job of having that technology, that interpreting services in the court. But I do believe that we could do better on the front end and answering questions for people before they even walk inside those double doors.
Thank you both so much. We've kind of come to the time that we promised you we'd try to get to. And in a minute, I'm going to ask you both to kind of wrap up why voters in the Fifth Circuit should choose you. But I wanted to talk to our readers to let them know that the Sentinel will be making an endorsement in this race, but we don't want you to stop there. Judicial candidates have the potential to interface with the people that they serve in some of their very most trying and stressful times. And so these are extremely high stakes races, if not for you, then for somebody you know or somebody that you have done business with. There is so much information that will be available in these races. Each of our candidates today has a web presence, be it through a website or or social media interaction. And take a look at both of them, what they had to say for themselves, and then compare them to your values and see how well they fit. But do not miss the opportunity to vote in this race, please. It will be on the August 20th primary ballot. And so what I'd like to do now is ask both of our candidates to give us their 2-minute pitch as to why they should be the one that you choose to vote for. And let's start with Mr. McCormick.
Thank you. I'm asking for your vote come August 20th because I'm going to be bringing my real world experience to the bench. I'm going to be taking my years in the public sector as an assistant public defender, my years on the civil bench as a civil litigator, my time and experience as a mediator, the insights that I was able to help compile as chair of the Judicial Nominating Commission, my time as a code enforcement magistrate, my time as a father and a husband, and bring that diversity of real world perspectives to the middle. I've been an advocate this whole time, and I like to joke that the best coaches were players before they started. And that's exactly what is needed to help ensure the efficient and respectful movement of cases, access to the legal system, and ultimately to the administration of justice. The priorities are fairly simple, but they do have to be implemented properly. The citizens need to know that when they walk into a courtroom, that they will be treated equally and respectfully. They need to know that however the legal system has touched their lives, that whatever that case may be, will be brought to its conclusion, whatever it may be, criminal, civil, family, in a timely and orderly manner. And they need to know that justice will always be done, even when it's difficult. And I intend to do all of those things, which is why I ask for the voters to choose me on August 20th for Circuit Judge.
Thank you very much. And Judge Davis, you have the final word.
Okay. First off, thank you to the editorial board of the Orlando Sentinel for giving us this opportunity to be able to reach out to our voters. I'll give you a little background information. I have been a circuit judge for the last 14 years. I was initially appointed in 2010. At that time, I served in both Hernando and Citrus counties, part of the Fifth Circuit. I was actually the first female judge ever appointed or to serve in Hernando County in 2010. So that was quite a female distinction, I guess. Eventually, I was transferred back to Lake County, where I presided for the last 12 years. I have sat on every case that comes before the circuit court, everything from adoptions, family law, probate, guardianships. And for the last 5 years, of course, I've been doing criminal felony work. I have done a number of jury trials, whether it be civil or criminal. I have done death penalty cases. So it's kind of the full gambit from adoptions to the least favorite things to do. I have done so, I hope, with distinction and with humility. I have never had to respond to a bar complaint or to a JQC complaint in the 14 years that I've been on the bench. And this is the first time I've drawn opposition. I believe that this job is extremely important, and I hope that the voters will take stock and look at the candidates for what they are saying and vote accordingly come August 20th, or early voting if that's what you do, or by the mail-in ballots. But in any case, I thank you again for the time and the opportunity to get to speak to you.
Thank you, and we wish you both the best of luck.